Indian courts will not enforce non-compete that simply prohibits a person from engaging in lawful trade or business, however competing it may be. The fact that it is in a contract signed by both parties makes no difference. The agreement is void. A pure post-employment non-compete in India, not linked to a business sale, will not be enforced. But the alternatives? Garden leave, walkaway fees, confidentiality, IP assignment, they give you a fighting chance. Not to permanently block competition, but to delay it. In a fast-moving market, that delay can be everything. Hello and welcome back to the Veyrah Law series. Today we deal with one of the most overused and misunderstood provisions in Indian contracts, the non-compete clause. It is there in almost every VC term sheet, every senior employment contract, every founder's agreement. It is negotiated hard, drafted carefully, and relied upon heavily. But unfortunately, in most cases in India, it is completely unenforceable. Let us try and understand why and what we can do instead. The standard non-compete clause in an Indian contract typically says something like this. The founder, employee, or counterparty shall not directly or indirectly engage with, work for, or assist any competitor during employment, and for a fixed period after leaving. Sometimes the restriction is for 1 year, sometimes it is for 2, and sometimes indefinitely. In VC transactions, investor agreements routinely require founding team members to be bound by non-competes as a condition of investment. The logic is simple. Investors are backing the founders. If a founder leaves and sets up a competing business, the investment value is at risk. For large MNCs and private equity-backed companies, senior management non-competes are considered essential to protect trade secrets, client relationships, and market position. All of this sounds perfectly reasonable. The problem is, it is not a legal contract under Indian law. Let us look at what the law actually says. The starting point is Section 27 of the Indian Contract Act 1872. It is crisp and clear in its terms. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is void. There are very narrow exceptions. The most important one being, a seller of a business and its goodwill can agree not to compete with the buyer within a geographical limit so long as the buyer carries on a light business. That exception is narrow. It applies to a business sale and not to employment, definitely not to a founder exiting from a VC-backed company during a dispute. It also does not apply to a departing employee. The courts have been consistent on this position. The general principle from a long line of Supreme Court and High Court judgments is clear. Indian courts will not enforce non-compete that simply prohibits a person from engaging in lawful trade or business, however competing it may be. The fact that it is in a contract signed by both parties makes no difference. The agreement is void. Not voidable. It is void. In non-legal terms, it simply means that you cannot get any remedy under law against someone who does not honor their non-compete obligation in a contract. All those pages of carefully negotiated non-compete language worth nothing in an Indian court. So what does this mean in the real world? Let us take the most common case. A founder falls out with their co-founders or investors. They leave the company. They want to start a competing business. The investors point to the non-compete clause in the shareholders' agreement and their employment contract. The founder's lawyer points to Section 27 of the Indian Contract Act. Gentleman's conduct kept aside, there is no legal right. End of discussion. The founder cannot be restricted from setting up a competing business. But all is not lost. There are some obligations that can be enforced. Non-solicitation clauses, preventing the departing founder from poaching employees or approaching existing clients. These are generally enforceable. Confidentiality obligations, preventing the use of trade secrets and proprietary information. These are also enforceable and should always be included. But the pure non-compete, that is a non-starter. And even for non-solicitation and confidentiality, enforcement through Indian courts is slow. Interim reliefs are not guaranteed. By the time a court acts, the damage is often done. So what can businesses actually do to protect themselves? Here is what we would recommend instead. First, accept the unenforceability, then structure around it. The starting point is intellectual honesty. A post-employment non-compete in India is unenforceable. Accepting that reality is the first step to building protections that actually work. The energy spent drafting and negotiating elaborate non-compete language is better spent on structuring alternatives. Second, use paid garden leave. Garden leave is enforceable in India. During the notice period, the employee or founder continues to be paid, but is required to stay away from active work. They cannot join a competitor while still on the payroll. For fast-moving businesses, even a few months of enforced absence can be enormously valuable. Market conditions change and teams move on. Business momentum is lost. In a competitive market, speed matters more than domain expertise. Garden leave buys you time. Structure a meaningful garden leave period into every senior employment contract. Be mindful that the garden leave should be part of the continued employment term as a notice period. It should not be a post-employment restriction. Third, include a prohibitive walkaway fee. This is a legitimate and often overlooked tool. In the employment contract, document the investment the company has made in the individual, training costs, time spent building systems, access to proprietary information, client relationships developed. Then include a prohibitively expensive walkaway fee, a contractual sum payable if the individual leaves and engages in competing activity within a defined period. This is not a non-compete. It is a damages clause tied to documented costs and investment. Indian courts are more receptive to liquidated damages clauses that reflect genuine loss, even if they will not award penalties beyond actual damage. The walkaway fee serves two purposes. It creates a genuine financial deterrent, and it gives you a damages claim to pursue, which can make any venture by the departing individual look considerably less attractive to potential backers. Fourth, strong confidentiality and IP assignment are your real shield. The most durable protection is not a non-compete. It is robust confidentiality and IP assignment provisions. Each of these clearly drafted, specifically identifying what constitutes confidential information and IP. These are enforceable in India, and they directly address the real risk, which is not that someone starts a competing business, but that they take your trade secrets and IP with them when they do. Invest in these provisions. Invest in access controls. Invest in data room discipline. The competitor you may be able to live with, the one who takes your business secrets on the way out, that is the real threat. Let us close with the honest position. A pure post-employment non-compete in India, not linked to a business sale, will not be enforced. But the alternatives? Garden leave, walkaway fees, confidentiality, IP assignment, they give you a fighting chance. Not to permanently block competition, but to delay it. To lock the violator in expensive litigation. To make the endeavor financially unattractive for anyone considering backing them. In a fast-moving market, that delay can be everything. As the late Justice Krishna Iyer of the Supreme Court of India once observed, law is not a brooding omnipotence in the sky, but a pragmatic instrument of social order. In India's non-compete landscape, that pragmatism cuts both ways. The law will not enforce what it considers unreasonable. So structure what is reasonable and make that work for you. Thank you for watching and see you in the next episode.